is an original determination today. So we can pray before your lordship that we want to move on 28. Kindly leave may be granted. Yes. Then, আমার old matter. Okay. ওগুলো দে, আমার ওগুলো কই? আপনি তো দিলেন না। বলে দিবি। Get full money. ফাইলটা নিয়ে এবার
Yes, inclusion for the list.
or monthly list, combined monthly list.
Regarding number 160 of the hearing, here Lord is a very senior. Wants to get this commissioner very senior. 25 years.
150. 150. এটা একটু ওকে একটু এটা আপগ্রেডেড। আপনাকে বলে যে পেনশন ম্যাটার গুলো গ্রুপ করা গেল না। You do one thing, you give a slip with a heading pension matter. আপনি পেনশন ম্যাটার যতগুলো পারবেন আপনার মাথা থেকে কিছু দিয়েছিল একটু একটা গ্রুপ করে দিয়ে যদি ইয়ে হয়।
One thing is that, Lord, the learned advocate for the other side was repeatedly directed by the Honorable Justice HON'BLE that affidavits to be given, but in spite of repeated direction, Lord, no affidavit was.
Okay, on that date. Yes.
Under compelling circumstances, I am mentioning item number 47. I know today is not possible. That matter, my lord, he is not getting pension. His pension has been withheld because of 3% additional.
Okay, give a slip pension matter, heading pension matter.
My lord, please to upgrade this matter.
Yes.
7, my lord, let it be listed, my lord, immediately, my lord, the reopening special fixed.
Yes.
He will not get pension.
47 pension matter.
I am also same thing. 3 matters is appearing, but I am giving the.
Give it the number. Yes.
My pension matter at the top. Otherwise, my lord, he is suffering, my lord.
Okay. এই একদিন এটা গ্রুপ করে দিয়ে দেবেন তো
47.
বুঝতে পেরেছেন? হ্যাঁ দেখুন।
I get to you.
Yes. Now call the list.
Number 1, Lord, item number 1, my lord, to get only direction
Oh.
for supplementary affidavit annexing that document.
My
We have
lord,
prepared the
So
supplementary.
what is your
instruction. My lord, what Mr. Wadi submitted just now, it is partly correct. Because it was fallen from your lordship, I have to answer the query.
whether it is agents
And I will produce the judgments also. These 2 points are also uttered by your lordship. My lord,
Okay.
kindly remember. Now, my lord, এই কথাটা বলা যাবে না, জজ বলতে পারবো না, বাজে কথা।
আর রেফারেন্স দিয়ে
Now,
দিলি
my
তো
lord, he is saying that we will answer. I will not answer, my lord. Today, my lord, I will deposit 2 pages notes of argument, my lord, in this matter.
have you given copy?
No, my lord, I have not given copy.
Oh.
In course of the day, I will give, my lord. In course of the day, I will give. My lord, I have prepared, my lord, and my lord, by preparing these notes of submission of 2 pages, I have, my lord, indicated the answer of Mr. Badi's query. The post was sanctioned. He, by putting supplementary affidavit, he said, I will only take 5 minutes, my lord, to place notes of argument. Only 5 points, 1 minute into 5 minutes I will take.
একটা কপি দাও, আমি তাহলে দেখে নিই।
Give a copy. You take first. Have you got a pair copy?
My lord, rough
Huh?
copy is there, my lord.
আমারটা দিন মিস্টার বাড়িকে দিন। Yes, you take it first, then
Let him submit.
বাড়ি যায় এই দুপাতা
Oh.
my lord, prior to that, my lord, kindly come to the page 49 of the writ petition before my notes of argument. একটা স্টেবল করে দাও না ভাই স্যার, দাও দিকে যাও। my lord,
yes.
page 49 says, my lord, তুমি ঘুরপাক খেয়ে প্রদীপ্ত বাড়ি চলে যাবে, একদম দাঁড়াবে পারে কি বলছো। In order, my lord, page 49 says, my lord, in order to ensure better utilization of fund under National Rural Health Mission and alleged program for construction and maintenance of health such and such department require for medical services in different hospital. My lord, last occasion I submitted, it was kindly project-based work. My lord, it is specific there, my lord, that required for medical service in different hospital. It is posted by the department for the creation of following post in the West Bengal for Service Corporation. By saying this such and post are there. So, my lord, these posts are created only for the service to the public, and it is a central government project. My lord, this is national it starts from the word I am repeating, utilization of fund under National Rural Health Mission. It means, my lord, it is central government project. We are just implementing authority for better to give supply in the West Bengal's government hospitals. For this reason, my lord, this post was created and these posts were sanctioned, and accordingly they are working. But it is not that, I will show from my notes of argument, it is not that they have got the regular appointment against the sanction post. Now, my lord, I am placing my notes of argument. My lord, kindly, my lord, 6 points are there. I will take 5 minutes, my lord. First point is this, my lord. It was in my submission. I humbly submitted before your lordship. It was temporarily appointment, and my lord, it was the contractual basis. I put, my lord, the appointment letter. Kindly take note that the, my lord, clause 4 of that appointment letter I have demonstrated earlier occasion that, my lord, it is purely contractual. Offer was there and acceptance was there, without any undue influence, without any fraud, without any collusion, nothing, without any pressure in English language, nothing was there. Number one, এটা বাড়িদার কিন্তু অস্ট্রেলিয়া স্লেসিং কাম দেবে না। 2 number, my lord, kindly to my lord, I have already submitted, they are getting different scale of pay as per our limited fund. We are trying to accommodate them, and my lord, under ROPA 19 they are getting advantage. Last occasion I could not submit it, it was not within my knowledge that they are also getting house rent allowances and annual increments, and they are getting, my lord, sub-assistant engineer are getting a salary of 79,583. They are not getting 400 or 150 like that. They are enjoying the scale of pay of 550,792 and 79,583. Last occasion it was not submitted by me. And it is, my lord, your lordship will get it in page 15 of annexure 2 of our affidavit in opposition. It is there, my lord. Number 3 is this, my lord, span of service. Mr. Badi submitted, and what was fallen from your lordship, I also, nobody had to appreciate, but I appreciated that. Oh, in one day we will throw him out. It is not that, my lord. In the, my lord, government memo dated 26 September 2019, I have annexed in my notes of argument as, my lord, annexure B. Their retirement age is page 60. I have written in my written argument. My lord, this is rare. Span of their service till 60 years. So prior to attaining the age of 60, nobody is there in the world to throw them out, my lord. Seek your job, my lord. And, my lord, the contractual question, my lord, if your lordship asks me, my lord, Mr. Chaudhary, how do you demonstrate this? My lord, offer was there. They have accepted. Until 60 they will work. They are getting 79,000, and it will be increased accordingly. As per our limited fund, we will increase. My lord, this was, my lord, not, this is instruction with not with me on last occasion. Number 4 is this, my lord. If your lordship, my lord, see, my lord, pay the letter dated 25th February 2011, clause 3. Your lordship, I have annexed it in P2 of my writ petition. Your lordship will get that, my lord. They are enjoying several, my lord, they are several interest, my lord. I am not placing it in whole, I have written in very small words. Thereafter, number 5, my lord, it is my submission that petitioners are working against sanction post. My lord, I humbly submit the state government by way of an order being number such and such created post. But clause 5 of the aforesaid order dated such and such, I have annexed this as annexure C. It says, my lord, I am just reading from this annexure. I am reading from this annexure last page, my lord. It is, my lord, prior to the back sheet, page 11.
Yes,
Page 11 top.
yes.
It is the note of the government where, my lord, posted sanction. Mr. Badi is perfectly correct, my lord. We have a fair counsel, my lord.
Yes.
My lord, engagement of personnel or contractual through agency from the market shall made by the corporation on the basis of a set of rules as may be recommended by the board of our company. So, my lord, against the sanction post, as when basis required, when our company will deem necessary and fit, they will engage the persons in temporary basis as per our limited fund, limited resources, limited, my lord, power. We have done the needful. Then, my lord, I am coming to my last point, last but not the least. It is the main point, my lord. What was argued before your lordship? It was fallen from bar that, my lord, in Uma Devi and, my lord, other cases, my lord, contractual employment, but post was sanctioned. My lord, I have demonstrated, my lord, that post was not sanctioned for a limited purpose. And, my lord, Uma Devi, what has fallen, I have stated in my lord, written notes of argument, paragraph 43 to 49 specifically says, my lord, kindly take note of this. Last two lines I am reading, my lord.
Yes.
The contractual employee whose appointments procedure are totally different from the regular employees cannot claim and or take the benefit as per with the regular employment. You know, Uma Devi categorically it was held, my lord. Because, my lord, as per advertisement was published, they produced their credentials. Thereafter, my lord, they sat for written examination. Thereafter, my lord, they faced vivavocy. Thereafter, personality test. So, my lord, several criteria are there. And in this case, my lord, they got appointment by catching Baba Kaka Mama. So, my lord, the sources are totally different. And Uma Devi has specifically dealt with the issue, my lord. Now, my lord, I want to produce, my lord, some judgment. I have referred in this matter, my lord. First, my lord, by the Honorable Justice Amrita Sinha, my lord, it was held in, my lord, my lord, it was held, my lord, similar point, my lord. My lord, it was held that, my lord, this type of employment cannot be regularized. It is, my lord, Amrita Sinha's judgment. And thereafter, my lord, it was my lord, upheld by the division bench of this court, my lord. It is, my lord, Honorable Justice Orijit Banerjee and Honorable Justice Apurva Sinha Roy. It was upheld by this honorable bench, my lord. A similar point, my lord. Contractual employee, casual employee, different, my lord, interview process. So, my lord, it cannot be regularized. It was, my lord, held, my lord. And thereafter, my lord, if my lord, one judgment, my lord, Justice Korgupta judgment, my lord, it was the division bench of the Honorable Justice Korgupta, my lord. Incidentally, my lord, I was junior to Mr. Honorable Justice Korgupta. Be that as it may, my lord, it was specifically held by the Honorable Division Bench of this Honorable High Court. Similar point, my lord. A contractual employee cannot be regularized against any type of post. It cannot be. It is, my lord, my lord, this is, my lord, Honorable Justice Dipankar Datta, my lord. It was held, my lord, similar, my lord. I am not reading same thing, my lord. Similar point was held by this. And thereafter, my lord, it is, my lord, Honorable Supreme Court, my lord, FX Court, my lord, in this judgment, Uma Devi, my lord, your lordship knows, I am just giving the my lord, copy of the lordship's convenience. And, my lord, yes. Now, my lord, last, my lord, what happened in honorable, one matter is going on before the honorable division bench presiding over the honorable Justice Homen Sen and Smita Das De. My lord, I am appearing in this matter on behalf of the university. I submitted before the honorable court these judgments, and after considering the judgment, his lordship thought, my lord, if possible, my lord, for consideration, some pay like this, if possible or not, like this case, it is possible or not, because they are getting 400, 450 per day, this type of salary they are getting. So I submitted before that, before the honorable division bench, that university is not the authority like this, my lord. State is the authority. Accordingly, my lord, his lordship was inter alia pleased to issue notice upon the honorable learned GP, so that state can appear in this matter. This is that order. Thereafter, state appeared, and, my lord, on that day, my lord, his lordship, my lord, division bench, my lord, so honorable judge presided over honorable division bench, my lord, hold that no final conclusion is not there, my lord. My lord, honorable division bench, my lord, directed the university, my lord, like this, my lord, this company, to take up the issue with the finance department of government of West Bengal and to submit a report before this court whether is it possible for them because they are getting 150, 450, 350. So, my lord, if some considered amount 30,000, 40,000, it was fallen from verbally from his lordship's court. 30,000, 40,000, 50,000. In this way, some pay package, date of retirement, what we have done in this case already. Some organization it was done. So, my lord, it was fallen from his lordship whether VC will, Honorable Vice Chancellor will take up the issue with the finance department of the government of West Bengal. How far is his accommodation is possible or not, at all possible or not. This is the latest position of this court. It was the judgment, it was the order passed by the division bench last few days back, my lord. Now matter will again come back and hearing will be concluded thereafter. This is so, my lord, in nutshell, my lord, most humbly, my lord, I am submitting before your lordship that, my lord, contractual employee cannot be regularized because of these judgments and this well settled position of law. But what can be done? That, my lord, honorable courts are several occasions requested the authority to take up the issue because some authority has done something, some pay packages are there, date of retirements are there. So this is the request and some authority are accepting the court's request and some authority are doing this out of their own. In our case, my lord, we have done it out of our own to put under the umbrella of a gentleman. We have done this because they are our like our son and daughter, we are the authority. We have done our level best. But apart from this, I think Mr. Haldar is there. The state government is not in a position to give this type of appointment, not in a position to regularize this type of appointment because, my lord, in several occasions, FX court and our high court hold that backdoor appointment or the appointment getting in other ways cannot be equally treated with the appointment who faced the interview process, my lord. This is my humble submission before your lordship, my lord.
Yes.
My lord, the past judgment I cited, my lord, the cursory view from this judgment was delivered on 8 January 2021. The law has been changed, sea change in 2024. Jago was not there, other judgment we have. Now, my lord, what there says, the judgment, your lordships kindly have a look to this page number to down, na? Page, Justice Sinha's judgment, page 1, 2, 3, 4. Page 4, although it is not pagination. 4. But you got it, page number. Justice Sinha's judgment, onno judgment gulo amra down, bolte parbo na. Ekmatro Sinha saheb page.
Yes.
Page 4. 12, unless there is some valid objection. But the page, it starts from unless there is some valid objection. The Lord, you got it? Judgment of Justice Sinha.
Oh.
Kaushik Ghosh. What's the state of
Yes.
Kaushik Ghosh. Page 4. Lord, you kindly take trouble. Page 4. Let's start unless there is some valid objection.
Yes.
Yes. Now your lordships kindly come. 5, 1, 2, 3, 4, 5, 6, 7. 7 paragraphs. The respondents contended
Yes.
that the petitioners were engaged as stopgap measure till regular candidates are appointed in the sanction vacant post. Completely different. That was the measures for the stopgap measure. And what is the contention? Appointed in the sanction vacant post till regular candidates are appointed. The petitioner do not have a right to be regularized in service without participating in proper selection process. Completely different. Because you have got your chance. Now, my lord, the selection process where it is undertaken, it is not that stopgap measures. You'll also kindly see the nature of appointment. Contractual appointment, initial for a period of 2 years. Thereafter, it is being continued last 11 years. And my lord, the reply of my learned friend has been considered in the Jago. If your lordship kindly takes up Jago one.
Now, one thing you clarify, he is saying that the post was created under a project to implement one project.
Whether it has been said so in the appointment letter. And this project was clear
It is their case, page 44.
in the reply. In the
There
reply,
the document.
in the reply, page 25, your lordship kindly.
So amendment will not serve the purpose.
Page 25. This, there. So, দেখালো আমাদের appointment notification.
Page 25.
Page 25. The decision of the directors. Page 25.
Yes.
Minute book. Evident in reply.
Hmm.
Lordship got it.
Hmm.
Evident in reply.
Yes, yes, got it, page 25.
With the above in mind, page 25, last point.
Last paragraph.
With the above in mind, the directors were of the opinion that the contractual employment of the existing employee, other than the person re-engaged and re-employment after superannuation, we are not the re-engagement or re-employment after superannuation, recruited through open advertisement, following the stipulated norms of the government, may be considered to take into a regular employment of the WPMCL, offering the benefits of existing payment and grade pay, along with the service condition in line with the employee of the government of the West Bengal. The government will be moved to accord approval that experience under this head be provided with the budget maintenance, thus will be need, therefore managing director requested to move the detailed proposal of the selection. Well, a contrary view can they attack their own order? There is a judgment of the Supreme Court that you cannot attack your own order. They have referred the matter to the finance. Government could have, because they have said that we have made a proposal, and my lord, the finance department rejected the prayer. To show they may say that we have made a proposal, and finance department, now that is their own declaration, own decisions. Can they challenge their own decisions? What they are submitting before the court? Then my lord, if your lordships consider the Jago, your lordships kindly have a look to the Jago. Once again, every reply and their oppositions in Roman 4 and 8, your lordships kindly have a look what they have said. Roman 4 and 8, their opposition. What they are saying. Page 7. Thereafter Jago I am coming. Page 7. They reply Roman 4.
Yes.
It is submitted that the West Bengal Medical Service Corporation Limited had issued a notice dated 25/10/2016 on the basis of the decision of the Board of Directors formation of the selection committee to regularize the proposal of the service of the contractual engineer, including the petitioner herein, in a phased manner, but the said regulation was not undertaken due to limited financial resource of the respondent company. There is no policy of the state government to this effect. In this context, it is furthermore the respondent company cannot exceed any proposal of the board director without the approval of the finance department. So they have proposed and they are agreeable. It is not the fact they cannot oppose their own decisions. Then my lord, the Roman 8, page 9. It is submitted
Yes.
that the regularization of the petitioner's hearing is subject to approval of the state government, for which financial assistance from the state government is required. In this context, it is further submitted the profitable respondent company is reducing day by day, except what the matter of required further repeat answer. Well, show their profit, I can show. I have used the supply. They are the profitable on how many crores they have been receiving and what is they are maintaining. I am not on that point, but I am on the plea that when they have proposed, they have forwarded the proposal before the finance department. It is for the government. They can say that we are not. But in view of the judgment of the latest Supreme Court, my humble submission would be before your lordships, it cannot be. Now, secondly, the Jago, your lordships consider paragraph 8. These are not before the earlier division bench or single bench. Now the law see change.
Yes.
Para 8. On behalf of the appellants, the following arguments have been advanced before us. Continuous and substantive engagement. The appellants emphasize their long uninterrupted service spanning well over the decade, and in some instance exceeding 2 decades. They argue that their duties were neither sporadic and not project-based, but permanent and integral to the daily function of the respondent offices. Nature of the duties, their responsibilities such as a cleaning, dressing, absence of the performance of the duties, compliance of the Umadevi guidelines, discrimination of the regularization, irrelevance of the educational qualification, equity and fairness. Thereafter, the nature of the engagement, absence of the sanction post, non-compliance of the Umadevi, they have been considered. My lord, now, after considering, my lord, the same, the Jago was delivered and they have been regularized. Oh, it's very mushkil. You argue. সেটাই ভালো হবে। Now, my lord, relying this judgment, latest Indian Oil Corporation's employee that I have coordinated bank judgment, I have handed up to your lordships. That is also. To show, my lord, my humble submission in view of the recent Supreme Court judgment, 3 or 4 judgments, and my lord, we have been recruited not on the basis of Baba Kaka Mama. It was recruited by the written test, computer test, interview, thoroughly, properly constituted selection committee. It is not, my lord, the as per choice. Regular recruitment route following the written test, computer test, interview.
সার্ভিস কমিশন থেকে হয়। ডিপার্টমেন্ট কখনো পারে রেগুলার রেফারমেন্ট দিতে, ওরা বাবা কাকা মামাই করে। ডিপার্টমেন্ট কখনো পারে স্যার?
Oh, Lord, side talk, please.
That
Yes.
my practice has been developed by Mr. Chaudhary. We are learning every day. What can be done?
Yes, yes. Written test, computer test,
Yes,
interview,
written test,
I mean,
computer test, and interview.
following a selection procedure.
Yes.
But my lord, not at par with the regular employment.
Reply to
selection
reply.
process. No, my lord, it is not that, my lord. Department cannot take the interview like my lord commission, because department takes his own person.
Yes.
See, my
The supplementary affidavit at produced on behalf of the petitioner is taken on record. Stop. Parties have concluded. ঠিক আছে, ঠিক আছে।
This is my application, Lord. Lord, in pursuant to the Lord, the RTI has been made for Lord getting the copy of the Weimar sheet in respect of West Bengal Group D recruitment examination held in 2017, Lord. And after that, Lord, yeah, he is.
I sought for certain information and also the copy of the OMR sheet. But that was not given. It was
What is the
also,
provision?
my lord, the SPIO told that
That one candidate appearing in an interview has got an enforceable right to compel the authority to hand over the OMR sheet.
or it was said that, my lord, it was be uploaded to the website, in the website. It was never given. Now the affidavit opposition, my lord, they did not say anything about uploading of the OMR sheet. They now intends to, my lord, give a copy of the OMR sheet. They contends that that my answer sheet was not assessed because of not writing the answer booklet series.
Answer?
Booklet series.
Booklet number.
Question booklet number.
Now let it be kept on record, my lord, and let the writ petition be disposed of.
And Lord,
That this is a copy
copy of the answer sheet
and
was given
also
to
the
the
affidavit.
আচ্ছা, ঠিক আছে। একদিন
certified as true copy from the original.
ও তো দিচ্ছে তো, তুই কেন দিবি?
আরে সেইটাই তো আমরা ইয়েতে রাখছি, এবার আপনি ইয়ে করুন আমার
আচ্ছা,
হোয়াটসঅ্যাপে
প্রেজেন্ট পিটিশন
It should have been
of the petitioner. That matter, my lord, tendency of this, my lord, writ petition, the information commission has, my lord, withdrawn their own order which is under challenge in this writ petition. So naturally, the writ petition is becoming infructuous.
Acha, yes.
The similar order has been passed by your
Acha,
lordship.
learned advocate for the petitioner submits that during pending
Yes, same.
6M ওনারা দিচ্ছেন বোধহয়
Yes.
সবকটা
সবকটাই
দিচ্ছে। হ্যাঁ 6M আচ্ছা 7 সেম
Same.
সেম
এটা দিলাম।
ডাকুন সেম
নাইনটা নেই দাদা, টেন
ঠিক।
করে দাও একবার।
হ্যাঁ? এই এক
নাইনটা মাঝে নেই, তারপর টেন।
4 থেকে 8 সেম
my lord,
অন্য 9টা করে নি আগে।
10টা করে দিই।
টেনটা একই শুধু
3
অর্ডার।
থেকে 8 হ্যাঁ এই 9টাও আছে নাকি
বা 9
My lord,
minus
9 is
9
different, my lord, 10 is same, my lord.
টেন ইজ সেম।
আচ্ছা 10 ইজ সেম 10টা সেম করে দিন 10 ইজ সেম ঠিক আছে
9 is I am frankly submitting you, Rosip, this is a very bad case of my client. Died in harness, made application for consideration. Made application for consideration considering the condition of the family. That application is pending. In the meantime, ex gratia was also paid. But
in the
sometimes
meantime
ex gratia amount was paid.
না এজ গেছি আমার
Yes, sometimes, my lord, the authority after hearing may be pleased to return back the ex gratia and to give him, offer him the appointment. Only my prayer may be the bad. Let them reject. Only consider of their representation. দাঁড়ান না। Matlab page P4 annex page 24 and 25. Let them reject. My client fate may be rejected by the authority. Let her go there and to produce the difficulty. If they at all satisfy, this is the mother's application, P4 page 24 and 25 is the candidate, petition number 2. State Bank employee, due to heart attack, he was bed this last. Only my prayer, in accordance with law, let them consider if they satisfy the authority, even after receiving the ex gratia, let it be considered in accordance with law. Otherwise, I cannot say anything before your lordship. Annex that
you want compassionate appointment for
Consideration.
whom for whom
petition number 2, married
Two.
married yet daughter. 2 daughters, one have given no objection, so 2 is claiming.
oh
And 1 is the mother. Only one, let them reject in accordance with law. I cannot
No,
answer.
my lord.
No, my
Practice-
lord. Kim.
বলতে দেন আমাকে।
No.
My lord, totally suppressing the entire fact, my lord, this petition is filed. Number 1. 2015 he died. The messenger was died. 2015. Immediately they filed an application for payment of ex gratia. Ex gratia was sanctioned. He was
আমি
getting.
বললাম
He was আমাকে বলতেন 26 লক্ষ 29 lakhs he got the retirement benefits, getting pension of 17,000, my lord, and took the ex gratia of 5 lakhs something credited in the account, and thereafter continuing 2021, my lord, there was no compensation scheme in the State Bank of India that time. Compensation scheme came to an end in the year 2005. Ex gratia scheme was there. Accordingly, 2015 he died, and 2015 he applied. He got the money of 2016 as acknowledgement in his account.
আর আমি তো বলেছি পেয়েছি।
আমাকে একটু বলতে দেন 5,96,000 টাকা ক্রেডিট হয়েছে, 17,000
That is
টাকা
retirement benefit.
আমাকে একটু বলতে দেন 17,000 টাকা পেনশন পাচ্ছে, সবই নিয়েছেন উনি। এবার রিটায়ারমেন্ট
ঘোষ,
বেনিফিট
PC
29 লাখ
ঘোষ।
টাকা পেয়েছে।
PC ঘোষ।
তারপরে 1921 সালে স্টেট ব্যাংক
Sir.
came with a compassionate appointment scheme, my lord, in the year 2021. In place of compassionate scheme, either of it came in, but that scheme came into effect, my lord. I have the scheme. It came into effect 16th of March. He died from 16th of March. Even if he dies, then the applicant, not 15. So 15, my lord. Now he is submitting 2 letters, my lord. Let them show the acknowledgement of those letters. We have not received the letter. Then now he got the information 2021 when scheme had come. Immediately say prepared something and concocted something
No, no,
and say apply.
when an application was made, they should have informed me that is rejected.
Give them, we have
No,
received
no.
it.
They should have informed at least
Scheme, my lord.
that your payer is rejected.
My lord,
That I want after hearing.
he got the exercia
Very good.
admittedly 5,96,000.
Sometimes it is directed
260
to
got it.
turn back with interest.
And he got pension, got his 70,000 pension that time. 29 lakhs
Then
retirement
it's not a
benefit.
dispute.
And she was happy. And married daughters is not entitled to the scheme.
Yeah.
Number one. Number two, so this is a position, my lord. Now, why they are coming, I'm explaining it. 2021, this is a scheme got the State Bank of India after 2005. 2005, scheme went away. There is no compulsory scheme, SGSA scheme. Then, my lord, 2021, they brought a scheme. The one can apply for exercia, one can apply for either of it, or commissioned appointment. That scheme specifically provides that it will be applicable after who had died after 16th of March 2021. This is a scheme. So taking a cue from that, they're now filing prepared one letter and approaching court to considerations, my lord. My lord, I see that scheme also. That scheme is not.
You consider and reject it. What is the harm?
Necessary. You have
Unnecessary.
you have taken this Garcia, you have taken the pension.
Let my
Just
client
for satisfaction of the
gets a
lawyer,
chance.
I cannot do it. It can be
No,
done.
no, no, satisfy
The
my
wife is drawing family pension.
His family pension. Family pension is
Family
getting
pension
Garcia
different.
taken and retirement benefits of 29 lakhs got.
And
And
that
thereafter,
is the,
from 2015 to
that is
21,
the
nothing.
benefit of the deceased.
2009-21, the scheme came, compulsory upon scheme or SGSA, either of it won't apply. If they fit in the
What I am
the
submitting my
terms and conditions
respectfully
contained
that
therein.
sometime
Now they take it to something came State Bank, he filed an application. And
sometime
that application, there is no proof that was
authority
submitted to the bank.
asks to
So bank
return back the
consider it.
exercia
It is never
with
submitted to the bank, my
interest.
lord. Or if it's submitted after 21 months now coming here, they are coming up. So therefore,
Let
this is
let
should
them
not be.
reject it.
Since
Well,
they have
kindly
accepted
pass this order.
exercia,
And let consider and reject.
not that is not easy, said, well, it's embarrassing for me.
And
my
the
lord.
embarrassing case at a
It is
direct
embarrassing
case.
for me to, because they have to go up to rejection.
them try
and
at
you
least.
the Chief General Manager, certain levels to cross it.
ভালো কথা
And why you have not brought it notice of a court, they will say me.
you have brought everything before the court.
Kindly think of the position of my investment, my lord. Clear instructions, clear scheme is here. And my lord, under what scheme they are asking, let them produce the scheme. Under what scheme they are asking compulsion upon. Let them tell.
Oh, it is with you. Okay.
Yes.
So is there any provision you record it and reject his
Yes,
claim?
yes, yes. That is.
Huh?
Here, my
Yes,
lord,
my lord, that is the
my lord,
order.
kindly again, my lord, it is embarrassing because so
Embarrassing
blatant case, my lord.
date of vacation,
After
not embarrassing, embarrassing.
Acha, the present petition has
but
been
that letter is not
primarily
with the bank, my lord.
ঠিক আছে
primarily praying for a direction upon the concerned respondent to
আবার তো ভর্তি হয়ে গেল বার করে দিল কেন আবার বার করে দিল কেন
appearing on behalf of the petitioner, my lord. One mistake is that, my lord. My lord,
Mistake, correction.
yes, correction only. In the order sheet of first matter, my lord, item number 11, thus in the server wrongly uploaded the cost title of Manuara Khatun instead of, and read petition number is also another. Yes, my lord. My lord, kindly see, I get the order from the server.
এ কি করেছেন আমরা দেখিনি, এটা কি যাত্রাটা টুকে দিয়েছেন নাকি? এটা মানোয়ারা খাতুন।
Yes.
No, no, 11464 of 2022.
Yes, my lord. My lord, one Manuara Khatun is a one of petitioner out of 5. But in 11464 WP, the petitioner is Aroti Singh Das. In Aroti Singh Das, Manuara order is uploaded wrongly.
তারপরে একটা ওর ঘরে ওরটা এর ঘরে হয়ে যাবে? সেটাই তো বলছি, কস্ট টাইটেল গুলো তো দেখে করেন। ধরে যা খুশি ছেপে দিয়েছেন মানে।
Another thing is, my lord, in second paragraph, the Sishu Shikha Kendra's name is different. In all order sheet, the Sishu Shikha Kendra name is Mohishadol. Sishu Shikha Kendra.
All the respondents are here.
Lordship, item number 11, Lordship, I am here. I am led by Mr. Bihani, Lordship.
Is there in two matters.
হ্যাঁ,
Mr. Rezaul Hossain is there in two
আপনি
matters.
সব তুলে নিন, তুলে নিয়ে প্রেস করে দিন। আপনি ওর থেকে ইয়ে করে দিন, ওদের কাছে বসে নিয়ে বুঝে নিয়ে করে দিন। আপনাকে ইয়ে করতে হবে, সমস্যা সমাধান করতে হবে। দিয়ে আমি অর্ডার গুলো তুলে নিন।
Only that.
You give the order which you have downloaded, which you have downloaded. হ্যাঁ, give the order, এই শুনুন, এই আপনি অর্ডার গুলো তুলে নেবেন, ইয়ে থেকে তুলে নেবেন, নিয়ে আপনি ওদের সঙ্গে বসে ঠিক করে দিন। You contacted and do it tomorrow, today,
Yes, yes.
otherwise yeah.
Yes.
Lordship, on last.
That means cost title
It will be the read petition number is different.
only one, Manuara,
Only
Manuara.
one. And
In place of Manuara, it has been recorded as Aroti.
Aroti
And the read petition has been
number is different.
বেশি ইয়ে নয়, আপনি ওটা
And
তুলে নিয়ে করে দেন।
And all in all orders, Sishu Shikha Kendra name is same. My lord, I am that.
Yes, yes, yes.
Lordship, on last occasion, Lordship, we missed out the matter, Lordship.
Okay. What you have uploaded here, learned advocate, learned counsel. What you have downloaded, you hand over the same. আপনি ওদের কাছে download. You also hand over. What is the other? There is three state, municipality, and who is appearing for the state?
Lordship, I am appearing for the state led by Mr. Bihani.
Who is for the municipality?
Lordship,
Mr. Sinha, most probably Mr.
Lordship.
Sinha,
Yes,
Dilip
Lordship.
Kumar Sinha.
Dilip Kumar Sinha, Lordship.
You give this information.
Yes,
ঠিক
Lordship.
আছে, হ্যাঁ। Okay. আপনি ওই সিনাকেও ডেকে নেবেন। You give, you tell Mr. Sinha, just if it is possible to come.
Yes, Lordship.
Yes. বিশ্বাস করা যাবে না কারণ সেই ডেট থেকে নাম থেকে সবকিছু মিলিয়ে দেখতে হবে বিফোর পুটিং সিগনেচার। এগুলো এম্বারাসিং না, এটা দায়িত্ব কেউ কাজে নেই। মানে জজ সাহেবকে সেই অর্ডার ডেট থেকে পিটিশনারের নাম থেকে সবকিছু তাহলে জজ সাহেবকে ইয়ে করতে। Yes.
This is my matter. I appear for the petitioner.
The opposition, my lord, respondent number 3 may be filed, my lord.
এই দেখুন কি ফাইল।
My lord, affidavits are complete, very short matter.
আচ্ছা,
If you not
এফিডেভিট
kindly-
এক্সচেঞ্জ
My lord,
between
kindly
the
just look at the earlier order passed by this honorable court. It is dated 27/9/22.
Hmm.
The entire facts and the issue is stated therein. My lord, may I place this order? Then, my lord, I'll take your lordship through the documents.
Yes, yes.
Lordship has found the order, my lord, 27th of September 2022. Affidavit of service filed in court today be returned with the records. The petitioner's grievance is that despite being exonerated of the charges in a disciplinary proceedings by the appellate authority of the West Bengal Small Industries Development Corporation Limited by an order dated 13 July 2020, the said order was reviewed by the Board of Directors on 22nd July 2022 and the disciplinary proceedings against him was sought to be reopened. The agenda in the meeting of the Board of Directors held on 22nd July 22 was for ratification of the decision of revocation of penal measures against the writ petitioner. But in effect, the Board of Directors sought to reopen the disciplinary proceedings against him and sought to appoint a retired judge as the appellate authority for hearing of the appeal of the writ petitioner. Consequently, the writ petitioner's claim for consideration for promotion from Assistant Manager 2 to Assistant Manager 1 with effect from 30th August 2022 was not considered, even though the writ petitioner was the first candidate in the seniority cum merit list eligible for promotion. Mr. Royal Learned Counsel, appearing on behalf of the petitioner, submits that the petitioner was exonerated from the charges by the order of an appellate authority dated 13 July 2020. And it was directed that the petitioner will get all benefits as if the penalty provisions were not imposed. Fixation of pay shall be worked out accordingly. The order will take effect from 10th July 2020. Pursuant to the order of the appellate authority dated 13 July 2020, the petitioner was given all the benefits of office order dated July 17, 2020. Thereafter, after more than 2 years from the date of order of the appellate authority, the petitioner's case was sought to be reopened and the disciplinary proceedings was sought to be reinitiated against him. He submits that there is no provision under the staff regulations of the West Bengal Small Industries Development Corporation Limited to do so. He draws the attention of this court to the provisions of appeal as stated at page 55 of the writ petition in support of his contention that there is no provision for review in the staff regulations. Mr. Basu Leonard, Senior Counsel, appearing on behalf of the respondent number 3, submits that as per Rule 50, Sub-Rule 3 of the staff regulations, the appellate authority was an authority that was prescribed by the Board of Directors, and in the instant case, no authority was prescribed to hear the appeal. Therefore, the Executive Director 2, who exonerated the petitioner of the charges, acting as the appellate authority, had no authority in law to act as an appellate authority since he was not the prescribed authority by the board. He submits that a wrong has been committed by the respondents, but they are well in their power to rectify the said wrong. Having considered the rightful submissions of the parties and materials placed on record, this court prima facie finds that there is no provision for review in the staff regulations. The writ petitioner was exonerated by the appellate authority on July 13, 2020. It is not possible for an employee to find out whether the appellate authority has been prescribed by the board once the employer themselves accept an authority as the appellate authority. The respondents took more than 2 years to find out that the said authority was not prescribed under the board. Furthermore, even though a submission was made from the bar that the executive director was not the appellate authority prescribed by the board, this court finds that no steps have been taken against the said executive director by the board. The writ petitioner has been issued a notice of hearing dated September 14, 2022 to appear before the newly constituted appellate authority, which the writ petitioner did not comply with. Subsequently, pursuant to filing of the writ petition, another notice dated 23rd September 2022 has been issued for appearance of the writ petitioner on the next date of hearing fixed on 12th October 2022. The subsequent notice dated 23rd September 2022 is handed in court today and the same is retained with the records. This court is prima facie of the view that there is no review provision and the respondents did not act within their power in reopening the disciplinary proceedings against the writ petitioner by ordering fresh hearing of the appeal. In the circumstances, the notice dated September 14, 2022 and the subsequent notice dated September 23, 2022 are stayed until disposal of the writ petition or until further orders. An affidavit in opposition is directed to be filed by the respondents by November 18, 2022. Reply, if any, thereto by November 25, 2022. Parties are directed to exchange advance copies of the writ petitioner affidavits. Liberty to mention for inclusion in the list under the heading hearing upon completion of affidavits. Needless to mention that in the event the writ petitioner is successful, his right to be considered for promotion to the post of Assistant Manager 1 will be protected with effect from 30th August 2022. So, Malad, this is the gist of the matter before your lordship. Now, Malad, kindly take few documents.
May I submit one thing? In this matter, I have been briefed just 1 day, 2 days, just yesterday night. But I have seen that the question of review is not the matter. Matter is this: whether the person who has acted as an appellate authority has taken up his own jurisdiction, he can do that. And I have found there are several judgments which, as if he has no power, then the appeal remains. Appellate authority at any time can take up the appeal and decide. But I have found several judgments which says that it can be done. But your lordship, today is the last date. If your lordship allow me some time, I'm not. If my learned friend places his argument, I am not opposing. I'm hearing, I'm taking notes. Your lordship, kindly give me some time to make my arguments, because I have yesterday night I have briefed. I have gone through the brief. But to some extent, I have able to understand. But the matter is not that whether the review is available or not.
May I place my case? Then my learned friend will say, what is the question? So may I place my case? It is a case of review. The court has held that it is a case of review.
Court is the interim order.
Very well. Let me substantiate it. That is your argument.
Only question is, here I have found.
That is your interpretation.
Whether an authority who has resumed his own power can act as an appellate authority.
That is not the case. Appellate authority was chairman. Chairman has done. I will place
this
it.
is my case. Let him submit.
Yes.
But I shall
place your
today,
case.
give me some time after vacation. I shall make my argument.
Only if the point that
today the hearing would not be concluded.
Hearing will not be concluded. I cannot, because I have to.
Today court will not be dispose of this matter, either passing order.
All your lordship record the
or even court will not be able to reserve the judgment also.
Only thing is this: your lordship, court kindly record this, the affidavit of opposition and replies in file. But my learned friend may continue. I shall take note. Your lordship, next day after vacation, I shall submit my. This is so that
So whether I'll fix the after
the point that my learned friend is seeking to argue.
Court is to address that point. Yes. After
in my respectful submission,
going through
yes. Your lordship will see. He says, what is, if I have understood correctly, he says that a wrong authority has passed an order. My submission is that the correct authority has passed an order, and now the board wants to reopen the issue, which is impermissible. Therefore, if your lordship finds that it is the correct authority which has passed the order, then this point need not be considered.
The question of reopening is not there. Question is whether the appellate authority can now take up the appeal or not. If the appellate authority is wrong, then the board can, the actual authority can always take the appeal.
That is not the point.
That is not my point, Malad. So
let me argue my point. How do you argue before my point? তাহলে আপনি বলছেন কেন আমাকে বলতে দিন প্লেস মাই কেস
বলবে তুমি আজকে তাহলে আর্গুমেন্ট স্টার্ট করে সময় নষ্ট করলে কেন I have placed my case so that I give me some time so that
I am not disputing that. You will do that, but first I have to place my case. I have to formulate my points. At the time of hearing my learned friend, your lordship will consider whether that point is to be considered at all or not. If so, then my your lordship will consider the judgments. But if that is not a point which is to be considered in the present cause of action, then my lord, the question of relying on judgments on that issue does not arise. I will only, my lord, take your lordship very shortly through the facts. What are the facts? Facts are, my lord, there was a disciplinary proceeding initiated against me. An order of punishment was issued. I preferred an appeal under the regulations. That appeal was decided, I say, by a competent authority. That order was implemented. In my respectful submission, my lord, this is important. It is implemented. After implementation, 2 years, nothing happens. Then, my lord, the question of promotion comes. A notice of promotion is given. I participate. Then, my lord, I will show from the documents itself why this proceeding is sought to be reopened. My lord, the union leader is against me. The general secretary of the union is against me. He gave a legal notice to the corporation saying that my disciplinary proceedings has not been done correctly. My appeal has been decided wrongly by a wrong authority, and therefore you reopen it. And it is on that basis that the board of directors say, they formulate an agenda and they say that yes, there is something wrong. So we appoint a retired judge and it should be reopened. That's one aspect of the matter. The other aspect I will show from the documents itself. Their documents, in their opposition, I will show this particular General Secretary of the Union did not participate in the proceedings for promotion. He abstained. It is recorded. Despite that, the board says that you promote him in the interest of the corporation. He is so powerful. I will show it from their records, from their minute book. Somebody who has not participated in this election process for promotion, the board says that all right, you promote him. That's the only reason why it is being reopened. And because of my lord's earlier order, my lord, of the coordinate bench, that what steps has been taken against the director, after filing of this writ petition, after the interim order, they issued a show cause notice to that erstwhile director. That how have you done this? And he replies, that is also very material. I have given it in my reply. And he replies and says that for 2 years, you didn't do anything. I retired. And now all of a sudden, because the court has observed, you give me a show cause notice. So these are the facts. I will place these documents, 4 or 5 documents. Then your lordship will consider whether it's a case of review, reopening, or it's a case of wrong authority. Now, my lord, kindly see.
Which department?
My lord, this is the West Bengal
Micro, small and medium enterprise and textile.
Industries Development Corporation.
The West Bengal service rules is applicable.
No, they have their own regulations. I have annexed those
Oh.
regulations. They have their own regulations. Now, my lord, first, I am not troubling your lordship with the complaint, the show cause notice, reply, all this, because that part has gone. Your lordship will first see page 41. This is, my lord, the
Page 41 of
the writ petition. Kindly see page 41 of the writ petition.
Yes.
Now, my lord, this is the order of punishment.
Reduction of
Yes.
pay.
Reduction of pay,
2 stage.
2 stages in the time scale pay for 2 years under rule such and such of the staff regulations. Now, my lord, kindly take the staff regulations. It starts at page 42.
Yes.
These are the staff regulations. Now, my lord, kindly take
The rank of the petitioner is
assistant manager 2.
assistant manager 2. Yes.
Now, my lord, kindly take page, it starts,
Start relevant portion.
yes, relevant portion, my lord, page 55, Roman 3. That has been recorded by her ladyship in, my lord, the order.
55 Roman. Yes.
Every employee shall be entitled to appeal from an order passed by an authority imposing on him any of the penalties specified in Rule 45 to such authority or authorities as may be prescribed by the Board of Directors.
Yes.
Now, my lord, kindly come to page 65. This is my appeal. Kindly see, Honorable Chairman and Appellate Authority.
Yes.
This is my appeal. Now, my lord, page 67 is the order which is communicated to me. Date, my lord, kindly mark 13/7/2020. The penalty provisions imposed by Sri Devanjan Guha, Assistant Manager, to write this order, earlier order number such and such, communicated by memo number such and such, is hereby revoked. Sri Devanjan Guha will get all benefits as if the penalty provisions were not enforced. Fixation of pay shall be worked out accordingly. The order to take effect from 10/7/2020. This order is issued with the concurrence of Honorable Chairman and Managing Director. So it is not he who is deciding the appeal. He is only communicating the decision. It is the Chairman and the Managing Director who have directed him, and the Executive Director is issuing the communication to me that this is the order passed, which is in consonance with the staff regulations. Now, my lord, page 68, your lordship will see. This is, my lord, 17th of July 2020, fixation of salary of Sri Devanjan Guha, Assistant Manager 2, in the pre-revised pay scale in pursuance of such order of 13/7/2022. Now, this appellate order is given effect to 2020. Now, my lord,
You appear in the written test and interview
yes,
for
I appeared. The notice was,
result was given.
result was given. I am the towards D, my lord, kindly see.
As your
70.
first candidate. Yes.
My lord, kindly,
Now they have given you promotion.
no. Just before that, they send it to the board, and the board says, my lord, kindly take page 72. Or, my lord, kindly take page 71.
Yes.
But page 70, your lordship has seen the merit list. I am the first empanel candidate. Kindly mark the date. It is 5th of July 2022.
Yes.
So on 5th of July 2022, I am the first empanel candidate for promotion. No dispute. Now, my lord, kindly see page 71. This is the agenda for the board meeting to be held on 22nd July. Now, my lord, kindly see the agenda. But agenda, kindly
To
see.
rectify.
Yes. What is the agenda, my lord? Kindly see, to ratify the decision of
Ratify.
to ratify.
Uh.
But when it comes to the decision, my lord, kindly take page 75.
Yes.
Now, my lord, on this is to ratify the decision, the agenda is there. Now, while ratifying, what they say, initiating discussion, chairman informed the board of directors that since legal retainer of the corporation has opined that there were non-compliances of the legal procedures in revocation of penal provisions of Sri Devanjan Guha, Assistant Manager, it would not be appropriate for the board of directors to take any decision on the matter. Chairman also opined that one retired judge may be appointed as the appellate authority for hearing of the appeal of Sri Guho AM2. Further, he informed the BOD that in similar case relating to hearing of appeal of Sri Raja Horijan, Assistant and Appellate Authority was also required to be appointed. After a threadbare discussion, it was decided by the BOT that the legal retainer be and is hereby authorized to appoint a retired judge as the Appellate Authority for hearing the appeals of Sri Devanjan Guho AM2 and Raja Horijan Assistant, and to take such necessary action and arrangements for hearing of the above stated appeals by the Appellate Authority. It is also decided that on receipt of the judgments of the Appellate Authority, the BOD will take appropriate decision in the matter of the above appeals. My lord, pausing here for a moment, I humbly submit, my lord, your lordship has seen the provision. There is no provision to appoint somebody else outside the corporation as the appellate authority. Neither there is any power of delegation. So I ask myself this question, if the chairman was not the authority, why he proceeded with it, why he passed the order, why the order was implemented, and then after 2 years, the legal retainer of the corporation says that no, this was wrong. Something already done, implemented. He says, no, this is wrong. The retainer says, nobody else. The legal retainer of a corporation says that this is wrong, and the board says that you appoint a retired judge and you reopen the proceedings. Can this be done? I ask myself, well, kindly consider this. So, what is in effect, what is being done? What is being done today is an appellate order is there. That order has been implemented. That is sought to be reviewed. The court doesn't, the board of directors doesn't say that it's a fresh proceedings or anything. They simply ignore the order. They ignore the implementation as if the appeal is still pending. Appeal was disposed of in 2020. Order implemented. My pay was refixed. And in 2022, they come and say that appoint somebody else and hear the appeal. There is no appeal on record. It's disposed of, implemented. That's the reason why I say that there has to be, it is in the nature of a review. And that review cannot be done if the law does not provide for a provision for review. I will be relying upon one Supreme Court judgment before your lordship. I am coming to that before I finish placing the facts. This is the position. So therefore, my lord, to come today with a submission that it's a wrong authority and it has been done, it does not say that chairman is not the authorized person. May I just one line again, read it again, my lord. Initiating discussion, chairman informed the BOD that since the legal retainer of the corporation has opined, there were non-compliances of legal procedures in revocation of penal provision on Sri Debanjan Guha, Assistant Manager 2, it would be appropriate for the board of decision to take any decision on the matter. What I ask myself this question, in their opposition, your lordship will not find anything. What is the legal procedure which has not been followed? They say it's the wrong authority, the director has done it. Record shows that it's not the wrong authority. It is the correct authority, and it is with the concurrence of the chairman and the managing director that this was done. Executive director is only the communicating authority. Now, my lord, kindly take, my lord, page 78.
Yes.
This is, my lord, this is relating to the selection. It starts at page 76. Minutes of meeting of the selection committee of WBSIDCL dated 24th August 2022. This is now, my lord, on the promotion part. Now, my lord, kindly turns over the page 77, your lordship will find for towards the bottom for promotion to the post of Assistant Manager 1, Debanjan Guha AM2 first rank. Now, my lord, kindly take the next page. Points for discussion by selection committee. Agenda number such and such to ratify the decision of revocation of penal measures imposed on Debanjan Guha was placed before the board of directors in its 362nd meeting dated 22/7/2022. Chairman WBISIDCL informed BOD that since legal retainer of the corporation has opined that there was non-compliance of the legal procedure in revocation of the penal provisions of Sri Debanjan Guha, it would not be appropriate for board of directors to take any decision in the matter. Chairman also opined that one retired judge may be appointed and such and such. Honorable Chairman made further observation at NSP 191 of file related to the departmental promotion that proposal of promotion of Debanjan Guha is kept in abeyance in the interest of public service. Now, decision taken by the members of the selection committees, the managing director WBSIDCL has directed the legal retainer to appoint a retired judge immediately, and disposal of appeal of Sri Debanjan Guha should be done in a time-bound manner after getting the judgment of the appellate authority. Decision for his promotion will be taken. Sri Sudeep Kumar Pal, AM2, ranked second, may be promoted to the post of Assistant Manager 1. But your lordship has seen that my promotion is protected by the interim order of this honorable court.
1 minute, Mr. Roy.
Well,
Mr. Sinha, there is a mistake done by them. One cost title, Cost title, there is a wrong. One cost title is different, order is, yes, same order was passed in respect of 5 matters. One cost title has been different. Have you downloaded that copy? Huh? You have not downloaded. আমি cost title ভুললেন আরে ইউ কনসাল্ট ওই যে ল্যাটের অ্যাডভোকেট বললো সে বলে গেল মেনশন করলো ভুল আছে হ্যাঁ তা আপনি সার্ভারটা একটু চেক করে দেবেন না না সার্ভারটাই ও বলতে চাইছে একজনকার নাটা অন্যটাই ওকে দে উইল ডু হ্যাঁ দে উইল ডু
আমার অ্যাপিল
হ্যাঁ হ্যাঁ 5 matters similar order was passed. One learned advocate mentioned one cost title has been, there is a mistake in cost title, and another cost title has been implanted. So we are trying to take instruction. Yes, yes, whether you have uploaded, downloaded the copy or not. ঠিক আছে আপনি তাহলে ওটা করে একটু ওনার সঙ্গে কথা বলে করে নেন ওকে দে উইল ডু ইয়েস ইয়েস
Now, Malad, page 78, I was taking your lordship through. Kindly, Malad, take the last box.
yes
This is D for promotion to the post of assistant manager 2 and accountant 2. Here, Malad, kindly mark this page, serial number 4, Sri
Yes.
Nochiketa Ghosh.
yes
He is the general secretary of the union. Did not take part in written test and interview. Kindly mark this part. I will demonstrate what happens. Now, Malad, kindly see. Observation, next page 79. Observation made by the Honorable Chairman WBSIDCL. The Honorable Chairman made observations at such and such to file related departmental promotion of Sri Nochiketa Ghosh, General Secretary of WBSIDCL Kormochari Somiti, had raised objection about legality of revocation of punishment of Sri Debanjan Guho through his letter and legal notice. As the legal notice as well as his letter of the managing director were not given due weightage to debar Sri Guho from eligibility list for promotion, Sri Ghosh, it should be, did not attend, Malad. This is a mistake. Sri Ghosh attended both written and test and interview with a note of protest, having no other alternative. In the larger interest of employees of the WBSIDCL, therefore, considering the above justifications, the promotion of Nochiketa Ghosh, General Secretary, WBSIDCL Kormochari Somiti, he is hereby approved along with other eligible candidates. So what happens?
have you made him as a party
No, I have not made him a party because I am not seeking any relief against him. My prayer is simply, Malad,
now
that-
if the promotional post is one
no, he is not in my category. He is in a different category.
oh
I am wanting assistant manager 2 to assistant manager 1. He is wanting to be an accountant. So we are not in this,
Relevant.
we are not same.
Relevant at all.
Why it is relevant, I tell your lordship, because what made the mind of the corporation change, that I want to show to your lordship. Sequence of facts your lordship will see. There was a complaint against me. There was a disciplinary proceedings held. I was punished. I preferred an appeal. The then chairman, with the concurrence of the managing director, allowed my appeal and gave me my benefits. Then, Malad, this was implemented. The moment the issue of promotion comes, this Nochiketa Ghosh sends a legal notice to the corporation. In the meantime, chairman, directors have changed. 2 years have gone. Now, Malad, the present chairman says that even though Nochiketa Ghosh has not appeared in the examination, let him be promoted in the interest of the corporation. Why? Because if he is not promotion, he will create problems there. He is extremely powerful politically. This is the main reason.
what is going on
Yes, that is what I am showing to you. I will show more. Malad, let him not answer just now. Let me finish, then he will answer because there are other issues also. Now, Malad, kindly take the opposition. Kindly take my learned friend's opposition. আর খুব বেশি। Now, my lord, kindly see page 34. I will not trouble your lordship through the entire opposition. Page 34.
So you conclude today what you judgment you will give?
I can't, my lord. I have just yesterday I have been briefed, but I can't. I can to his reply, I can go and add one sentence. Therefore, you also kindly allow me to make the next day. I cannot because well, from the beginning, for the reason of wasting court's time, I have submitted that I can't go today. That's why, my lord, that's the reason I have submitted before lordship from at the beginning. In spite of that, I have taken I shall take note. I have taken note. I have replied to that. I have replied to that all questions. Your lordship, I am not opening my mouth today. Next date, I shall submit.
Yes, legal notice. Yes,
Yes. Now, my lord, page 34, kindly see.
yes, legal notice of the Nachiketa Ghosh.
Yes.
Yes.
But two things your lordship will mark here.
Yes.
What is the date, my lord? 30th of June. Just after this election process starts.
Start.
And my lord, who are the clients? Kindly see the lawyer who is sending. One is Nachiketa Ghosh, General Secretary, and the second is Bandana Saha. She is the complainant, original complainant against me. So now they are clubbed together and this notice is sent. And on the basis of this notice, this is what happens. And one other page, my lord, page 44, kindly see. Yes. This is, my lord, a show cause notice they had issued to the director. After, my lord,
Yes,
this order, kindly see the second
who
paragraph.
is retired now.
Yes. But kindly see the second paragraph. This is to state further that the order of revocation of punishment of Sri Devanjan Guha AM2 was made by the undersigned in discharge of official duties with the approval of the then Managing Director Chairman, as would be borne out by the correspondent note sheets of the relevant file. This is also to state that the impugned show cause notice is intended to cover up the lapse on the part of the board, as pointed out by the Honorable Court in connection with the pending WPA such and such, wherein the respondents were directed to file an affidavit in opposition. This is what, and kindly Mala turns over the last page.
That has no issue with
Please,
this regard in the
why did you issue a show cause to him? If it
that
has
is
no
other
issue,
part.
no.
Let him challenge.
That
What is his part?
court,
I have
court
issued a
has
show cause to
observed
anyone.
this. Why I am making this up? You
But
will get your opportunity.
No,
What
that
is
is
the
a,
difficult?
that is an irrelevant point here at all.
Malad,
Nachiketa
if
Ghosh
it
is
is-
not a party, but the officer to whom the show cause notice has been issued is not a party here. But
I
why
am-
is unnecessary using
I
that-
am placing documents, your documents,
maybe
your opposition.
it is not at all
Why did you put
relevant
it
for
in
the
your
purpose-
opposition then?
It is not at all relevant for the purpose of deciding
Why did
whether-
you put it in your
whether-
opposition?
No, it is not required.
You have
No, no,
upon
it is-
documents.
it-
And
it-
when I place those documents, you are opposing. Well, I have never come across
But
this.
I am not such a loud voice. Only thing is this: the relevancy is this: whether the appellate authority passed the order is valid or not.
You withdraw your opposition.
Next, other things.
I
all
cannot
are-
accept your objection. You yourself,
This is your document.
rather don't take it otherwise. It's correctly pointed out. He is inviting my attention to the document annexed by you.
What I'm saying, but why
So
reason?
if you think that it is not relevant,
No, no,
so why have you annexed it?
not annexed it because but the authority who have passed reviewed the passed the
That
appellate
is to
authority.
justify your subsequent action.
Not that. You know,
That look,
whether
I am so fair, I am even sending the show cause notice to a person who has already retired.
I am grateful to your
well,
lordship.
already-
I have no, although I have no master servant relationship now, yet I am sending.
That is- but that is if it is possible. That is if the reason is this my appellate authority who has he's assumed his power on his own. For this reason, his show cause notice have been issued to him. No connection along with it.
Who you will say board of director is the appellate authority.
Board of Directors is appellate authority.
Yes. So show that provision.
Yes, but that provision is
Same
there.
provision, the board of director is the appellate authority. Chairman itself cannot act as a appellate authority. It would be your ultimate.
Ultimate, yes.
Yes.
Ultimate, yes.
Ah,
That is the
you are taking time. Court have understood what we will say.
But that is the
You will say this thing, that board of director is the appellate authority, and even if act is done wrong, that the authority concerned who has committed wrong, can rectify that wrong.
And
And you will produce some judgment. on
judgment
this
to that.
issue.
Yes, but that, Your Lordship,
So,
Your Lordship,
well, the court is unable to understand. So you can
Your
even
Lordship.
give the reference.
No, my lord, Your Lordship.
The
Well,
court will
I shall explain, my lord. There's something I shall explain.
that
And he has got his opportunity.
then it will be explain or elaborate this issue.
No, my lord, not only that,
Only the main thing will be except this, nothing can be
and
done.
factual aspects
Nothing
are
can
there.
be said.
Well, factual aspects are there. Where is the appeal? Where is the appellate order? Where's the where from? Whether these were approved by the board?
Now you show that board of directors is the appellate authority. As prescribed, it has been shown to me. That means a further prescription will come from the authority.
But
So
if-
you show that,
At the relevant time.
yes,
Come then.
you show that at that time you prescribe that he would be the prescribed appellate authority.
Your Lordship,
As per your
Your
prescription.
Lordship, I have
So
well,
here and now, yes.
my learned
Not
friend,
there,
my
otherwise it
learned
would have
friend
been
has
there with the
prepared the brief.
opposition.
Learned friend is aware of the brief from the 2 years, but I have just only yesterday night I have gone through the brief. You know, kindly give me an
Here
opportunity.
and now I have entered into the merit and everything. Here and now.
But Your Lordship,
I am saying here, sitting here, what would be your defense?
Your Lordship, I know that.
Extremely great.
Huh?
Your Lordship,
Even you have got at yesterday night, just now I have got it.
Your Lordship, I know that. That's why. That's
I'm
why.
ready to pass order
That-
here
that-
and now.
That's why Your Lordship is there. While we are here.
Huh?
That's why Your Lordship is there.
Unnecessary dragging the matter, nothing.
Yes.
That's suffering. From the
You
beginning.
find out judgment, your junior is there, you are there, find out the judgment, give it. If you don't,
That's the reason I at the beginning. I
My lord, what they have done at the instance of this person. I am an assistant manager one. This corporation has a go down in Park Circus. And there is a sweeper only there in Tangra. And Malad, he is last 3 years, he's made to sit there with a table, a chair, and a computer. There is nobody else, one sweeper and he. He's sitting there, no work is allotted to him. This is how they are victimizing him for the past 3 years. Salary they cannot stop.
Well, all these
Order
things
is already there.
All these things are not on record. Well, that's
It is
the
not
thing.
on record. Your
That's
Lordship
the
wants
thing.
a supplementary. If it takes time, I will file a
Whatever he
supplementary.
can file, he can
Malad,
file.
he is, that is
Whatever he
what
can
they are
file.
doing.
But the
It
question
was not
is-
done in 22.
the-
After that, they did it.
The question is
The manner in which
the
he is
relevant
being
portion. I
harassed,
shall argue in the last
cannot
next
imagine.
day. That person or that is what the question is there. What is it, whatever he can add his by an affidavit. I can also reply.
No, I will not give. I don't want to drag the matter.
okay, it is not a litigation of like nature, it's civil litigation. You
Therefore,
cannot say
I shall only take
The
one.
question was-
that court
I-
cannot take cognizance of subsequent fact.
Yes, I shall take only one day. I shall make
But
my
on
submission.
that date, you come with a document and
I'll-
supplementary affidavit,
Who was
which
the-
work you have assigned to the petitioner in the meantime.
You know, but that's not the person
Yeah.
here. He has been given work.
Yeah. No work, sitting there idle. He takes a book and reads it. There every day. He's been doing it.
Yesterday, in one order, I have mentioned that in jurisdiction, we started our journey with a motto that we shall extend our long arm at that place where injustice is found.
Grateful. Deeply obliged.
Thereafter, over the years, we have imposed certain self-restriction upon us. Article 226 has not imposed any restriction.
Unfettered powers.
There is unfettered
We
power.
have,
Unfettered power.
I know.
so we started our journey with this
I shall
motto
explain.
that we shall extend our long arm. And you cannot say that court cannot take
No, I
cognizance
am
of
saying on the
subsequent event.
I am not saying anything. I am just saying, let me give an opportunity to make my submission on the next day. I'm just
One
saying this.
authority will act fairly,
But that I shall try to
Yeah,
substantiate.
with reasonably.
I shall try to substantiate that what is there and what is not there.
After 2
But
years,
he has
certainly,
relied on and placed some things which he suits to him.
you just show staff regulation. Where is the staff regulation?
But he has done it.
Show the appellate authority.
Let him show.
Show the appellate authority. Where appellate
Page
authority?
55, my lord. Page 55.
I have seen
Page
that.
50?
Page 55 of the writ petition.
55. You will say board of director. Except this, you cannot say so.
But that is there.
You would be instructed to say this before this year. 55 as may be prescribed.
Prescribed,
As may prescribed.
prescribed. So you
So
should,
a further prescription from the legislature will come.
My lord,
So where is your
as you'll also kindly see 55, what I'm just as may be prescribed by the board of
yeah,
directors.
where is it? You show it.
So
By
where
the board
is-
of directors. Whether the appellate authority is acted, has it been prescribed? Has been prescribed. Anybody can take up in his own jurisdiction.
So
But
there
that
is no appeal.
Huh?
What do you say? There is no appeal.
appeal is still pending. That's why we have appointed a retired judge.
So you will.
I shall substantiate that. I shall substantiate my argument.
Okay, so you consider your condition. You are giving a substantive right upon a person to paper appeal.
Yes, Lord, it is there. It is there.
With a rider that the further prescription will be made, who will be the appellate authority.
Appellate authority. Will be
But
made,
you are not making this.
made these by the board of directors.
Oh, allow the court.
Yes.
You are not making this prescription.
Not only for him, but also for
That
others.
means you are snatching away the substantial right to paper appeal.
Well, at that time, well, if the appeal is being delayed, well,
Statutory right.
well, you know, see,
Forget about that.
well, there are
Statutory right to paper appeal.
well, I know, but there are several petitions being filed. The appeal is not been disposed of. Court has asked the appellate authority to dispose of, but that is not there.
Who is
He
the
has
appellate
assumed-
authority?
Well, at that time, there was the appellate authority.
And the person who is chairman is the topmost, I think,
But the
topmost.
board is not the chairman alone. The board is joint decision.
So,
I shall come.
so
I shall. That's one thing
that board decided that I myself would be the appellate authority. So,
I shall submit. You also kindly give us an opportunity. But well, I am not ready. Otherwise, I could have argued that I am not taking any day. Your Lordship knows me in the other matters. I am not taking any time. But for the reason at the beginning, I have told your Lordship. I am grateful to you.
as I heard Mr. Royal Learned Advocate representing the petitioner as and
Grateful to your Lordship for that.
কিছু হ্যাঁ দুইটা সব দুটোই নেবে কোন বেঞ্চটা কেন তাই দেখান তো ও আপনার খুব আনন্দ না আচ্ছা ওকে ইয়েস হ্যাঁ আমি তো রাত্রি পর্যন্ত থাকতেও রাজি আছি আপনি থাকবেন না সেটাই বলুন ইয়েস
Number 17,
I am for the petitioner in this matter, my lord. The writ petition was filed challenging the order passed by the West Bengal Administrative Tribunal. But unfortunately, the learned advocate on record filed this writ petition as WPA number. My lord, that is a,
You withdraw and file afresh.
I am praying for that, my lord. I am
Uh,
liberty to file afresh.
Learned advocate appearing for the petitioner.
It's a review matter. If your lordship kindly take it up because it will continue for a pretty long time, I believe, my lord. After vacation, it would be better because today also I am not ready.
Yes, after vacation,
Any
but
date, my lord. On reopening, my lord, any date.
whether you are going to change the nature and
No,
character.
no, that I already, my lord, took my lord information from
So
my client.
give that undertaking that you will not change the nature and character and person of the. Huh?
Yes, we give it.
Acha, yeah. So I am doing it.
All right.
Acha.
Difficulty is that, my lord.
Can undertake that you will not change the nature and character, your lordship.
Yes, my clients
Acha,
already.
at the outset, at the
I am
out.
just reading it. I am just reading it. Your lordship, kindly hear it. Although I could have opposed it also, but I am not opposing because at review stage, my lord, they cannot ask for any interim measure. Nevertheless, my lord, I am just reading it. On my query, they said, respected sir, we, Chanchal Datta and Ujjwal Datta are hereby declaring aftermath the verdict of Honorable Calcutta High Court. We did not make any construction on our land or did not indulge in any modification or apply to any higher authorities. The characteristics of the land is as it is as its previous condition without any modification or any change. They already intimated.
Okay, okay.
Yes.
Very good. It should
Basis
be.
I am making the
It
submission, your
should
lordship.
be. It
Yes.
is expected. It is expected.
Expected.
Actually, in our
Yes,
country, we
but
have
I
to
know
pass
that-
this order. When our citizen will acquire that conscience that since a court of law is
Yes,
in
yes.
sessions of matter, we should not do anything to give a further complication to
Naturally, my
the
lord.
issue.
I also, as a
To
deputy,
add
my
a
lord-
further complication to the issue. And hence, such sort of interim order is required.
Yes, my lord.
At the outset, Mr. Chatterjee, learned advocate, repenting the opposite party, submit that this matter may be placed in the list after the ensuing summer vacation.
Any date may be fixed, my lord. I have no objection.
Acha, after summer vacation.
Well, after vacation, you also kindly fix up a date, my lord.
Date. It
Oh,
will be
okay.
better.
Yes, I'm state respondent.
For the petition, my lord.
My lords, in item number 19, I beg to appear virtually. In this matter, Mr. N.C. Bihani is appearing for the respondent, the Regulated Market Committee. My lord, he is not present today. I am praying that this matter be taken up after vacation. Also, my lord, there are certain factual aspects. We have received oral instructions. Certain factual aspects need to be brought on record. I'm praying that a direction be passed so that we may file our affidavits.
No affidavit, no
Need
direction.
lordship, that is instruction has come. Then meaningless, finally read petition.
My lords, I have
Okay, okay.
instructions that
Yes, instruction has come.
What they are paying for?
I'm praying for state. Yes,
Construct,
the whole
my lords,
construct
22
newly
Yes, my lord.
said.
no, yes.
Lordship
It-
kindly,
Yes.
Adjacent to the existing,
Yes.
existing wholesale fish market.
Yes.
my lord.
Already allotted. He is doing business. Other fish trader
Allotted
has been
to-
demanding. Other fish
Malda,
trader is
Malda.
why you is the local standing to
Malda.
file the writ petition? Is it
No,
given
my
in
lord.
two case?
No, my lord, petitioner number, my lord, 1 and 2.
Yes.
My lord, they are the, my lord, fishermen and my lord, petitioner
Other
number.
fish trader has
Now, my lord, petitioner
why
number
you
3, my
are
lord.
disturbing them?
My lord, he is the secretary of my lord,
Correct.
Malda Jela Motso Vyavasai Samiti.
Hmm.
Now, my lord, they are running their, my lord, fish market in their respective stall. My lord, through, my lord, they got the stall, my lord, in open tender. My lord,
Payment
open tender, my lord, that was conducted by my lord.
স্টেটের ব্যাপার তো বোঝেন তো No.
How court
Lord,
can,
respondent
court
number
can
2.
enter into this?
Now, my lord, what happened, my lord? Lordship kindly see my representation.
They kindly allow,
Now, my lord,
assist the court to understand the nature of the dispute.
yes, my lord.
You are a fish seller.
Yes, my lord. My lord,
You are a
my lord, what?
organization of the fish sellers.
Yes, my lord. Secretary, my
Yes.
lord, is secretary.
The Malda Jela Parishad
We are
constructed.
going to set up a my lord, new fish stall, my lord, in front of my
Already
in
new
front
has
of
given
my-
the
Now, my lord,
another
if my lord,
is disturbing.
that fish stall, my lord, will be, my lord, fish market will be installed
Other
in
fish
front of my, my lord. We have no objection, my lord, if they, my lord, my lord, construction of fish stall, my lord, will be made adjacent or my lord, beside, my lord, the existing fish stall. What, my lord, they are going to construct in front of my, lord, existing fish market. So, my lord, naturally, my lord, our business will be prejudiced, my lord. Several different
Right, you have got.
Now, my lord, several
It is on their land. It is the land of the Jela Parishad.
Yes, my
They
lord.
are going to make this construction on their own land.
Now, my lord, we
So
also,
what?
now, my lord, we also.
What right you have got that you
Yes.
will not allow anyone to construct
No, no, no.
anything in front of your sub room?
No, my lord, Lordship
What
kindly-
right you have got?
Lordship kindly see my representation, my lord, annexure P4. page
Forget
20.
about the representation.
Now,
Forget
my
about that thing.
Yes, my lord, no,
Yeah.
neither any communication nor any reply, my lord, they are going to
They
construct.
give a representation and seeking a direction
my
to
lord,
consider the
lord,
representation.
my lord,
Forget about the.
My lord, the existing, my lord,
Court will consider whether the direction should be given for consideration or not.
my lord, my lord,
Yes.
Lordship,
Forget about those.
Lordship kindly consider, my lord.
Eh?
Lordship kindly
Consider
consider.
and
My lord,
dispose
those,
and
my lord,
dispose of
Lordship kindly
property.
consider, my lord, those who are, my lord, existing, my lord, are running their existing fishery business, my lord, they got their stall through open tender, my lord, conducted by, my lord, respondent number 2. And, my lord, so far land is concerned, my lord, they got lease, my lord, for last 30 years.
Change that idea and thinking. It was old thinking.
Now,
If I remain
wait.
alone, if I remain alone in a place,
Yes.
my sale will increase. No. If it is created, a market is created, sale will increase.
No, my lord,
That's thinking
but,
is
but,
it.
my lord,
Ah,
my lord,
People generally does not
but my
want
lord-
to go the particular businessman.
but, my-
People wants a market.
but, my lord, proposed fish market, my lord, it is nearer to my road. So, my lord, our business will be prejudiced, my lord. Lord, kindly
What is
consider.
the right?
My lord,
What is your right to prevent other from doing same business
no, my
in
lord,
the vicinity of your shop room? What
no,
right?
my lord, we have, my lord, while, my lord, the inspector, my lord, they came. Now, my lord, we have shown that, my lord, there are sufficient place, my lord, adjacent to our, my lord, existing
It is
field
their
market.
choice.
No, my lord, lordship kindly
It is that
consider, my lord.
you show us that you have an enforceable right to compel them to construct
No, my lord,
only adjacent to your shop,
my lord, lordship
not
kindly
in front
consider,
of
my
your
lord,
shop.
my lord, this is, my lord, under,
You
my lord, my lord,
notice here, ready to pass this order here and now.
my lord, their business will be prejudiced, my lord, my lord,
That cannot be a consideration.
their business will be prejudiced, my lord.
That cannot
My
be a
lord, my lord, if,
consideration.
my lord, no place is,
What is your right?
my lord, if no place is there, then my lord, this is okay. But my lord, there are sufficient space, my lord. And my lord, if
Okay. The
lordship kindly,
present
my lord,
petitioner has been preferred, primarily seeking a direction upon the respondents to construct the newly fishery sets in adjacent to the existing wholesale fish market. Existing wholesale fish market. You are Mr. Ghosh. Mr. Ghosh, learned advocate, representing the petitioner, submit that the petitioners are
my lord, in these hard days, my lord, they will be, my lord, out of, my lord, their
petitioner are the fish sellers by avocations and their
one group will be get
fish sellers by avocation, comma, and they are operating their business from the stalls allotted to them by the Malda Jela Parishad. Stalls were allotted by the Malda Jela Parishad.
Yes, my lord.
Two.
No, it's allotted by, my lord,
Market committee.
my lord, respondent number 2, my lord. Malda
Constructed
Malda
three
Malda
numbers
Jela
of big
Regulated
size
Market
cover
Committee.
set.
My lord, district magistrate is the chairman, my lord. Respondent number 2, my lord. Malda Jela Regulated Market Committee, my lord.
Where from you are operating your business? From your self-owned sub-room or from the sub-room allotted by the Jela Parishad?
Room allotted by, my lord, respondent number, my lord, Malda Jela Regulated Market Committee, my lord.
Acha, allotted by the Malda Jela Regulated Market Committee.
My lord, we got the stall
Stop.
open tender, my lord.
Acha, stop. Acha, market
Proceeding, my lord.
following a tender process.
Right, yes.
Following a tender process. Stopped. He submits that subsequently the petitioner came to learn that the Malda Jela Parishad took initiative to set up certain stalls for the fish sellers in front of the petitioner's shop room. In front of the
New market, we allot some stall and then
Acha, petitioner's stalls in front of their shop room.
adjacent to NH.
In front of their shop room.
Yes, my lord.
Acha, stop. He submit that sufficient land and or space are available
Yes.
in the vicinity of the petitioner shop rooms, and the Malda Jela Parishad can utilize that space and for setting up the stalls for the fish sellers.
Malda
Because
Jela
if
Regulated Market
he
Committee.
submits that if the Jela Parishad is allowed to set up any shop room or stalls in front of the petitioner's shop room, petitioner's business will be hampered. Stopped. He pressed for an appropriate direction to restrain the Jela Parishad from taking any such initiative, which may have a pernicious effect, which may have an adverse effect on his business. Stop. Acha, Mr. Guha Vishwas, learned advocate, repenting the
Regulated Market Committee, not Jela Parishad. Malda Jela Regulated Market Committee.
Acha, Malda, they are going to construct.
Authority, Malda Jela Regulated Market Committee. District Magistrate is the chairman, not Malda Jela Parishad. Respondent number 1, my lord. Lordship, file is
You,
the Jailer Regulated Market Committee.
I have said, yeah, what I say, you, when you, it is your year, when you cannot convince the court, you confuse the court. It is your. Who allotted? Two answer. Who allotted initially shop room to you?
Malda Jailer Regulated Market Committee.
Who is now going to set up the shop?
Malda Jailer Regulated Market.
আচ্ছা সব মালদা জেলা রেগুলেটেড কমিটি করে দেবে আচ্ছা হ্যাঁ ইয়েস আচ্ছা মিস্টার গুহ বিশ্বাস, a learned advocate appearing for the state, produced a written instruction and submits that under a program to set up certain fees, a big size to provide space to the fish seller to operate their business, the Malda Jela Regulatory Market Committee constructed 3 numbers of big size covered fish set comprising 65 numbers of stalls in first page. ঠিক আছে? For the traders and businessmen for doing business from those stalls. আচ্ছা subsequently, since demand of stalls of like nature increased in the locality, the committee decided to construct some more fish shed in the vacant space and on land of the adjacent area of the old/existing wholesale fish market. Stop. And accordingly, the committee constructed 2 more big size cover fish set in the adjacent of old/existing wholesale fish complex as proposed by the Secretary Malda Jela Motsyo ব্যবসায়ী Committee and other fish traders and businessmen of that locality. So, the petitioners are raising some issue unnecessarily, and there is no, there is no violation of any provisions, or the petitioner has not been prejudiced by such action taken by the committee. Stop. You are appearing for?
My lord, Mr. N.C. Bihani appears for the Regulated Market Committee in this matter.
Acha, what is your?
Well, I am his chamber junior. I am not briefed in the matter, but
Mr. Bihani is in court today.
My lord, he is not present in court today.
Okay, yes, I am here. Acha, Mr. Mukherjee, learned advocate, repenting the regulated committee, ছোট committee করে দেবেন। What is your instruction?
My lord, we have received oral instructions that justifying our decision to shift the market from one place to another on the instructions of the government and on public demand. That was
that in compliance with the instruction from the government, the decision for construction of further fixed in the adjacent area was taken. Stopped. heard the learned advocate appearing for the respective parties and peruse the materials on record. Stop. The petitioner himself admitted that those presets were constructed on the land allotted to the regulated market committee. Stop. And as submitted by Mr. Gohorai, the cover preset was constructed as proposed by the Secretary, Malda Jila Motsyo Byabsayi Samiti, and other fish trader and businessmen. Stop. The petitioner has failed to show that he has a enforceable right to compel the regulated committee not to construct any such fish shop in the vicinity of the area where the petitioner fish shop is located, on the plea that the setting up of further fish shop in that locality may adversely affect the petitioner's business. Therefore, I do not find any merit in the petitioner contention, and accordingly the writ petition is dismissed. However, no order has to cost. Dismiss. যাও 8 মিনিট আছে এই তো 5 মিনিট
Because if I may just submit.
Your name will be recorded. Since Mr. Behani, had he present in the court, his name could have been.
No, I'm submitting that, my lordship would be pleased to record that I'm submitting on oral instructions because we have not received anything in writing from the market committee as of yet. That is why I was praying for time to file an affidavit, but my lordship.
No. Yeah. Okay, submit upon instruction.
Lordship,
Oral
wait,
or written. Okay. Next. Anything? Oh. Here I have to go. দুটোর সময় তো হবে না বলে দিয়েছে ওরা। আপনি কটা পেয়েছেন? একটা তো ছোট কাটা। আচ্ছা, মনে হচ্ছিল যদিও না আমরা তো এতদিন যে কিছু বেলের অর্ডার দিয়ে দেবেন তো আমরা পেনটা কি হবে একটু দিয়ে দেবেন রেজলিউশন হয়ে যাচ্ছে। আচ্ছা, যদিও আমরা এতদিন ধরে দিয়ে এসছি। না ওই যে আপনি বলেছেন ছোট করতে ঠিক আছে।
We have a resolution at 2 p.m. so we are not counting.
I have a bench, different bench at 12.
Division bench.
After division.
Lordship,
After vacation.
after vacation.
From 2 and onwards, you have resolution. How?
Item
You have
number
taken-
20. If your lordship keeps any date after the 23rd, your lordship perhaps is not there till 23rd. What I have been informed.
What is the urgency? So you mention it on 23rd.
They want a singing permission in a bar.
It's basically,
Singing permission in a bar.
it's a live band. It's basically, respondent authorities also wanted a clear report from the police authorities, which was given without any reasons. Without even they wanted to wait for the police report. Without waiting for the police report, the district magistrate went ahead and refused the license. I asking for a remand and a fresh hearing upon receipt of the police report. That is what I want.
Okay, come on 23rd. Come on 23rd.
Well, it may remain in the list in that.
একটু দিয়ে দেবেন তো ওনারটা।
It's a 2-minute
Okay.
matter.
Okay, okay.
They are also agreeable. So now nothing matters.
তুই তাহলে আজকে আর বসবো না আজকে আর বসবেন না তার উপর ডিফল্ট হলে অ্যাডভোকেট বলে নেই না আর জিপি অফিস আর যদি না না জিপি অফিস নেবে কেন জিপি অফিস কি পাগলা বুঝতে পারছে বলে তো আমরা নেবো না জিপি অফিস কপি নিতে গিয়ে ভালো ঝামেলা করে লিভ ম্যাটার নিতে গিয়ে ঝামেলা করে সেখানে এটা এত সহজে নিয়ে নিল